Call the case of the People versus Jason Smith.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Count Overwater Assistant Public Defender on behalf of Mr. Smith, who is in custody.
Before anything even begins, understand the stakes of what you're about to watch. This isn't a full trial, this is a preliminary examination, and that changes everything. The prosecution doesn't have to prove guilt beyond a reasonable doubt here. They just need to show probable cause. That means, is there enough evidence for this case to continue? Now look at how this opens. Calm, procedural, almost routine. But beneath that surface, both sides are already positioning themselves. The prosecution is preparing to present a witness who will anchor the entire case. The defense, on the other hand, is already thinking about how to dismantle that witness before the case even gets off the ground. And here's what makes this situation especially interesting. The defendant is already in custody. That subtly shifts the tone. It adds pressure. It signals that something serious has already been alleged. Watch how the prosecution sets up the witness. Polite tone, offering breaks, even pointing out tissues. That's not just kindness, that's strategy. It builds credibility. It frames the witness as vulnerable and cooperative. And in court, perception matters just as much as facts. But here's the real tension. Everything is going to come down to one key claim, an alleged physical assault. And if that claim holds, even with weak surrounding details, the case moves forward. If it cracks, everything falls apart. So as this unfolds, focus on three things: consistency, clarity, and credibility. Because in this courtroom, those three factors will decide whether this case lives or dies.
State your name for the record, Mr. Smith.
Jason Charles Smith.
All right. Taking time to have a preliminary examination. Are we ready to proceed?
Yes, Your Honor.
All right.
It's ready, Your Honor.
And call your first witness.
I would be calling Marie Bradley, and our victim advocate has gone out and I'm going to grab her right now.
All right.
You see, raise your right hand. Swear to affirm the testimony you're about to give with the truth, the whole truth, and nothing but the truth, so help you God. But have a seat. State and spell your first and last name for the record.
Thank you. You may inquire.
Thank you very much for being patient with us today, Ms. Bradley. I really appreciate you being here. If at any point you need to take a break, just let me know, okay? And there's tissues to your right if you need them. Do you know a Jason Smith? How do you know him? Okay. And is he in the courtroom now? Can you briefly describe something he's wearing and where he's sitting? Your Honor, please let the record reflect that the witness has made an in-court identification of the defendant.
Record shows so reflect without objection.
I'm going to direct your attention to September 17th, 2023. Okay? Were you at 930 North Congress Street in Ypsilanti, Michigan, Washtenaw County at that time? On that date, did the defendant do something that made somebody call the police?
Yes, struck me in the face.
Okay. Can you break that down for me a little bit?
Now we're getting into the actual narrative, and immediately you can feel the uncertainty. The witness is trying to explain how this started, but there are interruptions, pauses, and gaps. That matters. The prosecution is attempting to guide the story, but the witness isn't delivering a clean, linear account. Instead, we're hearing fragments. He wanted me to go in the room. I don't even remember yelling. That kind of phrasing introduces doubt, even if unintentionally. And then comes the key detail, the porch. The location is established, but the sequence of events is still unclear. That's important because in any assault case, context is everything. What led up to it? Was there escalation? Was there mutual conflict? But notice what the prosecution is doing. They're not pushing too hard on the unclear parts. They're steering toward the moment that matters most, the alleged punch. Because if they can lock that in, they don't necessarily need every detail before and after. From a legal standpoint, this is a calculated risk. The more you dig into unclear memory, the more room you give the defense to attack.
How did it start?
It started because he wanted me to go in the room and leave him alone.
Where were you? I apologize for interrupting. You said he wanted you to go in the room. Where were you when this started? Outside? Okay. And What happened when you were on the porch outside?
When he was telling me to go outside and leave him alone. We were both intoxicated, I didn't want to leave him alone. And, I don't even remember him yelling at me. He closed his touched me in the nose area
On the front porch?
on the front porch.
Okay. And did he say anything else other than to leave him alone prior to punching you? Okay. Do you know how many times he hit you? Once? Okay. And can you tell me what happened after he hit you?
We just sat there, was talking,
Afterward?
yeah. I mean, it was kind of a normal thing. So I just wiped the blood off and kept rolling.
Okay. And did you call the police or did someone else?
What do you?
This section raises one of the most subtle but powerful questions in the entire case. Who actually called the police? The witness didn't. That's confirmed. So now we're left wondering, what triggered law enforcement involvement? Was it a bystander, a neighbor, someone passing by? And here's why that matters. When a victim calls the police, it often signals urgency, fear, or immediate harm. But when someone else calls, it introduces a layer of separation. It suggests that the situation may have looked different from the outside than it felt from the inside. Then we hear that nothing else physical happened after the alleged punch. That's another key detail. No escalation, no continued violence, just one incident. Now legally that doesn't invalidate the charge. A single act can still qualify, but from a narrative perspective, it raises questions about intensity and context. And here's where things get interesting for the defense. They now have multiple angles: unclear memory, lack of direct police call, and minimal continuation of conflict. So consider this carefully. Does the absence of follow-up violence make the incident seem less severe? Or does it simply reflect how unpredictable real-life situations can be?
Had driven by, had some witnessed it, and
Objection, Your Honor. We're getting into either speculation, hearsay.
I'll sustain the objection. Go ahead. Next
But you
question.
did not call the police?
no, I did not call the police.
Okay. Did anything else physical happen between you and the defendant on September 17th, 2023?
No.
Okay, 1 second, Your Honor, please.
Yes.
No additional questions at this time.
All right, cross-examination.
Thank you, Your Honor. You indicated that you and he had been drinking.
Yeah.
How much did you have to drink?
I couldn't tell you. But
When you say a lot, could you be more specific?
I honestly don't remember.
More than 5 drinks?
Absolutely.
More than 10 drinks?
Probably up to 8.
What were you drinking?
It would have been, whiskey and coke,
Whiskey?
or it was my car lemonade.
Well, which one were you actually drinking that day?
Oh,
You don't recall what you were drinking. Were you using any other substances?
Yeah.
Anything else? Were you using crack? So how much marijuana did you use?
probably 2 pre-rolls. Grams.
So you had 2 pre-rolls and at least 8 drinks.
Yep.
And those drinks might have been whiskeys. They might have been Mike's Hard Lemonades.
Right. Yeah.
Fair to say that you were intoxicated,
Absolutely.
highly intoxicated.
This is where the defense takes control, and they go straight for the most critical weakness: intoxication. The numbers alone are striking. Multiple drinks, possibly up to 8, marijuana use, and then the confirmation, highly intoxicated. That's not a minor detail. That's a central issue. But the real turning point is when we learn the police took the witness to the hospital against their will. That tells you the level of impairment was significant. This isn't just casual drinking. This is extreme intoxication. Now, from a legal perspective, intoxication doesn't automatically make someone unreliable, but it does open the door to serious doubt about perception, memory, and interpretation. And the defense knows exactly what they're doing. They're not arguing that nothing happened. They're arguing that what the witness believes happened may not be accurate. That's a powerful distinction, because if the court starts questioning whether the witness's memory is distorted, then every detail, even the alleged punch, comes under scrutiny. So here's the question. At what point does intoxication stop being a background detail and start becoming the defining factor of the entire case?
So much so, in fact, that the police took you to the hospital, correct? Against your will.
Yep, I made sure that he wasn't going to jail that day.
So the police took you to the hospital because you were so intoxicated.
Right.
When you get intoxicated, does it affect your recollection of things?
Okay.
Did it affect your recollection in this case?
Yeah, up until about the punch.
So you don't remember what happened before the punch or what happened after?
Being upset that I kept following him, wanting to talk to him. Oh,
When you say he's upset, what was he doing?
yelling at me.
Okay, you testified earlier that you don't remember him yelling at you.
I don't know. Well, I mean, that's just our usual thing.
Okay. You testified earlier that you don't remember him yelling at you.
Okay.
And now you're testifying that he did yell at you.
Well, okay, I can't say whether he yelled or not, but he was telling me to go in the bedroom and look.
Okay. So now he didn't yell.
I don't remember.
You don't remember.
No.
Okay. So when you testified just now that he was yelling at you, was that untrue? Did you remember it then and forgot?
I don't know.
Did he, in the course of this incident, lock you out of the house?
I don't remember on that day when they left. No, I don't believe so.
No? Do you recall if you tried to break into the house by popping open the front screen door and entering the residence?
No,
You don't recall, or that didn't happen?
no, it didn't happen.
Okay,
Not that
so,
I recall. No, I have to say that, not that I recall.
okay. Do you recall if you tried to pop the screen off the back door to enter the house?
Not at that time, no.
Do you recall going into the house on that date?
Oh, yeah, in and out, beautiful day out.
Okay.
Now the defense tightens the pressure, and you can see the inconsistencies becoming more visible. The witness shifts between remembering and not remembering. One moment, certain actions are denied. The next, there's uncertainty. Then partial recall. This kind of fluctuation is exactly what defense attorneys look for. Because in court, it's not just about what you say, it's about how consistently you say it. Notice how the defense asks about entering the house, trying doors, moving around. These questions aren't random. They're building an alternative narrative, one where the situation may have been more chaotic, possibly involving actions the witness doesn't fully recall. And then comes another subtle point. When intoxicated, does the witness ever fall down? The answer, not that I recall. That's another crack. Because it suggests limited awareness of their own behavior while intoxicated. This isn't about proving anything definitively. It's about stacking enough uncertainty that the entire testimony becomes questionable. So think about it. If someone can't clearly track their own actions during an event, how confident can we be in their interpretation of someone else's actions?
Yeah,
When you're intoxicated as you were on that day, do you ever fall down?
No,
No?
no,
No, I said ever.
no,
So when you get really drunk, you don't ever fall down.
no.
Not that you recall. May I have just a moment, Judge?
Okay.
No further questions, Judge.
Any redirect? You may step down. Thank you, ma'am. Any additional witnesses for the people?
No, Your Honor.
Any witnesses for the defendant?
No, Your
Motion,
Your Honor, the people move to bind over on count one.
response.
Honor, defense would object. There's no evidence to support that there was any injuries, no pictures. There's no testimony from any other witnesses to support that this even occurred. The complaining witness freely admitted she was extremely drunk. She was abusing both alcohol and marijuana at the time, to the point, as she testified to the officers on scene, forcibly took her to the hospital against her will. She is not a reliable witness at that level of intoxication. The court is well aware that it is obligated to consider the credibility of the witness, and she is not credible. I would ask the court to dismiss the charge.
Now we reach the legal core of this entire phase, the judge's decision-making process. The defense has made its argument clear. No physical evidence, no supporting witnesses, and a heavily intoxicated complainant. On paper, that sounds like a strong case for dismissal, but listen carefully to how the judge responds. The court acknowledges the credibility issues. That's significant. The judge is not ignoring the problems. We've just spent several minutes hearing them. But then comes the key legal distinction. Those issues are matters of fact, not grounds for dismissal. In simple terms, the judge is saying this. Yes, there are doubts. Yes, there are inconsistencies. But those are for a jury to evaluate, not for the court to resolve at this stage. And that's the power of probable cause. It sets a low bar. If there's any reasonable basis to believe a crime may have occurred, the case moves forward. So here's the critical takeaway. This decision is not about who is right. It's about whether the question is serious enough to deserve a trial. And that leads to one question. Should a case with visible weaknesses still move forward simply because it might be true?
Court does believe that it's an issue. It's a question of fact as to what she remembered. She clearly testified that the defendant punched her in the face, that she was bleeding. As to issues regarding her recollection of other parts of that event, again, those become, I think, issues of fact, weighing certainly on her credibility, but not to the extent that this court doesn't believe the people have met the burden of probable cause. So for those reasons, the court would bind the defendant over as charged.
Now just see to the information, waive its formal reading. My client will stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
1:30 before Judge Slay Monday.
April 22nd, 2024, 1:30 Slay Monday. Thank you.
Thank you, Your Honor.
Yeah.
Court does call the cases of the People State of Michigan versus Tamar Young, case 23 FB 1433 and 23 F2.
Now we transition into an entirely different case, and immediately, the scale shifts. What we're hearing now involves multiple counts, amended charges, and even references to a murder victim. This is no longer a single incident being examined. This is a complex, multi-layered prosecution. Notice how the attorneys discuss adding counts, dismissing others, and restructuring the charges. This is strategic. Prosecutors adjust charges based on evolving evidence, witness availability, and legal positioning. And then comes one of the most serious developments, an added count of open murder. That dramatically raises the stakes. From a legal standpoint, amendments like this are significant because they reshape the entire trajectory of the case. They determine what the defendant is ultimately facing and how the defense must respond. But also pay attention to how smoothly this is handled. No drama, no emotional reaction, just procedural clarity. That's how high-level courtroom operations work. So consider this. When charges evolve this significantly before trial even begins, does it strengthen the prosecution's case or reveal that the situation is still unfolding and uncertain?
0334.
For the
Counsel.
record, the Michigan Senior Assistant Prosecuting Attorney on behalf of the people for both cases.
Good afternoon, Your Honor. Susan Longsworth on behalf of Mr. Young for the 23FB case.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Tamar Young on 23F20334.
And what are we
Going to be waivers on both cases.
on both cases?
And with regard to file number 23FB-, that's the case that Ms. Longford representing.
Yes.
I'm just putting on notice for the court's benefit, although counsel is already aware of it, that we're going to be filing amended information to reflect certain changes in circumstances from when the case was originally filed.
Hold on one moment. Let them finish the conversation because I'm having,
Oh, is there feedback, Your Honor?
no, I'm hearing you while Mr. Gannett is
Sorry.
talking.
I apologize, Your Honor. Thank you, Your Honor.
Go ahead, Mr.
Ms. Longsworth and I had discussed the case over the weekend, yesterday. Count 2 is being dismissed because that was originally charged when And unfortunately, the victim on that case was a murder victim ultimately. So count 2 will be dismissed on the information, and we're adding a count 13 of open murder with Tyrese Burks being the named victim on that count.
All right.
And then when you're ready, I'll keep going through the changes that are happening.
Okay, hang on. So you're going to be adding a count 13 of open murder.
This moment is massive, and it might go unnoticed if you're not paying close attention. The prosecution is formally restructuring the case, and adding an open murder charge is not a small adjustment. That fundamentally changes the stakes. Here's what open murder means in practical terms. It allows the jury to decide the degree, first degree, second degree, based on how the evidence unfolds. In other words, the prosecution is keeping its options wide open. They're not locking themselves into one theory of the case just yet. Now combine that with multiple additional counts being added, 14, 15, 16, 17, all tied to serious offenses like discharge of a weapon into a building causing injury. This isn't just stacking charges randomly. This is strategic layering. Each count represents a different angle, a different way to secure a conviction. From the defense perspective, this complicates everything. It increases exposure, increases potential sentencing, and forces them to prepare for multiple legal theories at once. And here's the key detail. The judge is following along carefully, confirming each change. That matters because every amendment must be clearly understood and properly recorded. So think about this. When prosecutors expand charges this aggressively before trial, are they strengthening their position or revealing just how complex and uncertain the case really is?
Okay, go ahead, sir.
Count 2 dismissed, added count 13. Moving down to count 6, that will be, the language will be amended to reflect that it was a death to Tyrese Burks for the discharge in or at the building causing serious impairment. That would mirror count 7 with the other homicide victim being Travis Williams, if the court follows.
So count 6, I got you. Okay, so count 6, the theory or the basis under that will change. Is that?
Sorry, that would coincide with count 5 of Dallas Williams.
Yeah, okay, count 5. That, okay, thank you. All right, that makes sense.
And then when you're ready, I'll finish this off.
Yeah, no, go ahead.
We would also add counts 14, 15, 16, and 17. All 4 of those counts are going to be the same felony firearm. They're going to correspond with a felony of discharge in or at a building causing serious impairment. And essentially they correspond with the charge counts 5, 6, 7, and 8.
Got it. So 14, 15, 16, 17.
Yes, sir.
All right. So effectively, is that everything?
It is, Your Honor.
So effectively, if the defendant were to waive, he'd be waiving over on count 1, count 2 through 17.
2 is dismissed.
I mean, 3 through 17.
Yes,
Thank you.
sir. That's correct.
Slongsworth, is that a correct statement as you understand it?
That is a correct statement, as I understand it, Your Honor. If I may inquire of Mr. Young.
Yes.
Mr. Young, you heard some of the changes that Mr. Ganatra put on the record pertaining to the information that they'll be filing. Is that correct?
Yeah.
Okay. And do you believe that you and I have had a sufficient time to talk about the case, talk about the benefits of holding a preliminary examination and the benefits of waiving a preliminary examination?
Yeah.
Now we see a critical legal decision being made, the waiver of the preliminary examination. This is one of those moments that might seem routine, but it carries serious implications. By waiving the preliminary exam, the defendant is essentially saying, we're not going to challenge probable cause at this stage. But that doesn't mean surrender. In many cases, this is a calculated move. Why? Because sometimes the defense doesn't want the prosecution to preview all of its evidence early. A preliminary exam can give the defense insight, but it also gives the prosecution a chance to refine its case, lock in witness testimony, and fix weaknesses before trial. So by waiving it, the defense might be preserving flexibility, avoiding early exposure, and focusing on a stronger strategy later. Notice how the attorney carefully confirms that the defendant understands this decision. That's required. The court needs to ensure this is a knowing and voluntary waiver. and the defendant agrees. So here's the question. Is skipping this step a smart strategic move or a missed opportunity to challenge the case early?
And in converse, the cons of both of those as well, right?
Yeah.
Okay, and do you understand that you are giving up your right to hold a preliminary examination, and you're agreeing that the government would be able to show probable cause of these felonies if we were to hold a preliminary examination? And you and I have talked about other evidence and possible defenses and other mitigating factors that were present. And we've agreed that those are issues that we would raise at trial if necessary. Do you agree with that?
Yeah.
Okay, so understanding all that, is it your agreement that you are going to waive your right to preliminary examination in this matter?
Yes.
Thank you. No additional questions, Your Honor.
And young man, that is what you want to do?
Yes.
Pardon?
Yes.
People also waive their right to preliminary examination, both men. All right. And sir, you also understand, we talked mainly about case 1433. You also understand in the other case, you're waiving your right to a preliminary examination.
Yes.
All right. Preliminary examination having been waived, and let me start with case ending in 334. Defendant is bound over to circuit court on that single count. In case ending in 1433, defendant will be bound over on count 1 and then 3 through 17, as will be reflected in the amended complaint.
For my case, Your Honor, please waive reading. I can acknowledge receipt of the information. Mr. Young stands mute.
And this one.
Your Honor, we waive formal reading, stand mute, and we acknowledge that we have been informed of and will receive a copy of that amended information when it is prepared.
Defendant having waived formal reading in all of the cases to all of the counts, waived formal reading and standing mute to those charges, court will enter a not guilty plea. Pre-trial in these matters will be set
April 1st at 1:30 before Judge Slay Monday.
April 1st, 2024, 1:30 before Slay Monday.
Thank you, Your Honor.
Thank you. Bond will continue as set and or denied in each case.
And I did sign the information for 334 and provided to the court.
Yes, we do have.
Andrew Meyer on behalf of Major McIntyre. Mr. McIntyre, if you haven't done so already, please state your name for the record.
Mazio McIntyre.
Thank you.
All right.
Your Honor, I do want to make one correction. I do note that last time we were in court, there was representations made that multiple calls were made to the victim after arraignment. However, I do believe only one of the calls was made after arraignment. That is completely my fault. I do want to note, however, I do have a full spreadsheet of all of the calls that the defendant has made to the victim since he has come into custody, not just.
Now we enter a completely different kind of issue, post-arraignment behavior, and this is where things get dangerous for the defendant. The prosecution admits an earlier mistake about the timing of calls, but immediately replaces it with something far more serious, a pattern of repeated contact attempts with the alleged victim, and not just 1 or 2 calls. We're hearing about multiple calls across several days, even involving other inmates' phone access. This is critical because court orders matter. When a judge imposes restrictions, especially no contact orders, they are not suggestions. Violating them can have immediate consequences. But here's what really stands out: the escalation. Multiple calls, different methods, even using other inmates' PINs, that suggests intent to bypass restrictions, not just a one-time mistake. From a legal standpoint, this shifts the focus. It's no longer just about the original charges, it's about compliance with court authority. So ask yourself, if a defendant ignores clear court orders, how does that impact their credibility and their chances of being granted any leniency moving forward?
Since the 26th, but also have after he was remanded by Your Honor, including 4 calls on March 7th, 1 call on March 8th, 3 calls on March 10th, and 2 calls on March 11th. I do also have an email from Lieutenant Arnett indicating that there were multiple inmates disciplined this weekend for letting the defendant use their PINs in order to contact the victim. I also have a couple transcriptions from the additional calls made between the 7th and the 11th of this month. I do want to apologize
No.
for that, error with the dates. However, I do want to emphasize that our initial request for bond modification was not solely the result of the jail calls. We did feel that the initial bond being set was inappropriate because of the escalating pattern in this case, with the destruction of the same victim's property on January 7th, escalating to malabuse on January 9th, and then the actual act of physical violence that occurred at the end of February. So we were planning on making a bond argument even without the jail calls being in play.
So just so that I'm clear, and I understand what you're saying in terms of the calls, because sometimes I have to make sure that I have the arraignment as opposed to custody date when trying to assess these. But then after he was remanded this time by the court,
That is correct.
there are more calls.
That is correct. And I have a spreadsheet and transcriptions if you would like them.
Mr. Meyer.
Your Honor, thank you, and thank you to Ms. Barroso for correcting that. I mean, this was something we had discussed yesterday. I was reviewing the calls and noticed that some of them did occur before the arraignment.
Okay.
But in terms of where we are now, Ms. Barroso did make me aware of these additional allegations of calls. I don't have those yet. I only have the ones that would have occurred before the arraignment. So that's the.
So what, you don't have the calls
I don't have the.
basically from this week,
Correct. I don't have those.
this past week.
Right. So I'm not in a position where I can assess what was or was not said on those calls, to whom those calls may or may not have been made to. So I'm in a little bit of a disadvantaged position in that regard. But here's what I'll say.
But those ones are new.
Correct.
Here's what I'll say. Mr. McIntyre and I discussed this.
This exchange reveals something subtle but extremely important. The defense is operating with incomplete information. They admit they don't yet have access to the newer calls. That puts them at a disadvantage, especially when the prosecution is presenting new allegations in real time. But notice the strategy. Instead of disputing unknown details, the defense concedes what they can. Yes, calls were made, but avoids commenting on content they haven't reviewed. That's controlled lawyering. You don't argue facts you don't fully understand yet. However, the judge isn't focused on content alone. The judge is focused on behavior. The fact that calls were made at all, despite restrictions, is already a problem. And this is where the legal lens shifts again. Sometimes it's not what was said that matters. It's the act of violating the order itself. So think about this. Should the court wait for full evidence before reacting? Or is the act of breaking the rules enough to justify immediate consequences?
Regardless of what's on those calls, Your Honor did order him not to make any call. I think I reviewed the ROA and it said no phone privileges were revoked. So putting aside what may or may not be on those phone calls, there's a violation. He'll admit to that part of it, that he made a call when he wasn't supposed to make a call, and we'll just leave it at that.
Made a call?
Made calls, excuse me.
And that becomes part of my problem, part of my dilemma. Because at that, I mean, if it isn't clear from the magistrate and you make the calls, then once you get here, I kind of make it clear, and I revoke your phone privileges, and I kind of make it clear you're not to have contact. And even though I say it, write it, do that, you still just do it. And so in terms of release of this defendant, I don't know that I can trust this defendant to follow any of the court's orders regarding it. I mean, that's the dilemma that we're in.
I don't mean to pile on, but I do want to also raise one additional concern that came out of one of the jail calls, because it did appear to me from one of the calls made prior to arraignment that the defendant indicated that if he thought he was going to be in custody, he would leave court.
He would what?
He would leave court. And so that to me poses an additional concern of him not wanting to appear if he were to be, if custody were to be on the table.
I mean, in terms of ties to the community, I think I brought this up last time, and he does have a place that he was staying in Ypsilanti prior to him being remanded by the court last week. And he did have a job. I don't know if he'll be able to return to it. I was just in candor to the court, just trying to admit to what I think we can admit to this point, which is that there were phone calls. I just don't know what the content of those calls are.
Right, and Mr. Myers, I often have to indicate to people, for the purposes sometimes of these bond hearings, certainly I'm concerned about what the content may be, but a lot of times that content is really potentially being used for what might be additional charges or other motions if the victim doesn't appear or the like. The bottom line to it, though, is you said no contact.
Right. And that I can't assess whether there was contact with an alleged victim or not at this point. I don't know that after arraignment. I don't have anything in front of me. I do have phone calls that.
Do you, so,
To see it.
Sure. But I didn't have it until.
yeah, right.
Is this your file?
No, I have 3 if the court wants one too.
Just while you're also going through that, what is even more problematic is I take away the phone privileges in hopes that when we come back here, there can be at least an understanding, but then apparently he's using somebody else's PIN to potentially try to access.
This is the breaking point. The judge now clearly sees a pattern, not just of violations, but of deliberate attempts to bypass the system. Using another inmate's PIN to make calls? That's not accidental. That's intentional. And in a courtroom, intent matters. The judge emphasizes something critical. He already made the rules clear. No contact, phone privileges revoked. Yet despite that, the defendant continued. At this point, the issue isn't just non-compliance, it's defiance. From a legal standpoint, this severely damages the defendant's position. Courts rely on trust. If a defendant shows they cannot follow basic orders while in custody, it raises serious concerns about what they might do if released. And notice how the tone shifts. The judge is no longer evaluating possibilities. He's reacting to behavior that has already happened. So here's the key question. When a defendant repeatedly ignores court orders, does that become more damaging than the original charges themselves?
They're trying to say a call. My sister. He's trying to say, I don't know.
But these ones.
No, it's not.
Yes, it is.
No, it's 26.
It's a problem.
It's only them ones right there.
Right. It's after. Do you understand?
And Your Honor, I do want to note that some of the calls were made to a different phone number, but that phone number was referenced in a call from 3-7 to the victim's phone number as a number that would be the point of contact for the defendant to the victim. So that is how we have that information. And that is the number that the defendant was using. Inmate William McDonald, Kamani Hamilton, Rontrell Davis, and Dominic Kelly Payne's pins in order to contact. Excuse me, not Rontrell Davis or Dominic Kelly Payne. It was just William McDonald and Kamani Hamilton. He used Rontrell Davis and Dominic Kelly Payne's number or pins to contact the original phone number, just so we're clear.
Your Honor, as I said, happy to admit to the calls they make. That's all I can admit to at this point, or have him admit to.
No, I got you. Well, and just to put it bluntly, I mean, I told the defendant no contact. Well, the court has told the defendant no contact. We restricted his phone privileges upon his remand. back on the 7th of March. Between the 7th and the 11th, really, but certainly within this week's period in time, he's then entered into a scheme to sort of thwart the court's order, both the original order as well as the new order that that his phone privileges were revoked. So for those reasons, the defendant won't be released. The revocation of bond will continue. The defendant will stay in custody. You can bring it up with Judge Perry on his set on the 19th, so you can go from there. Thank you. He set this Tuesday
Yes, the 19th.
for preliminary.
This final decision brings everything together, and it's a direct consequence of the defendant's actions. The judge makes it clear, bond will not be reinstated. The defendant remains in custody. And the reasoning is straightforward, not just the charges, but the behavior. The court explicitly states a lack of trust. That's critical. In bond decisions, trust is everything. It's not just about whether someone committed a crime. It's about whether they will follow the court's rules moving forward. And in this case, the answer is clearly no. What makes this outcome particularly significant is that it was avoidable. The violations, calls, attempts to bypass restrictions, those weren't forced. They were choices. And each choice added weight to the court's decision. Now the case continues, but under stricter conditions. The defendant will have to fight this battle from custody, and that changes everything. Access to resources, communication with attorneys, overall strategy. So as we close this case, here's the final takeaway. In the courtroom, it's not just what you're accused of, it's how you conduct yourself while the case is unfolding. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.